Thank you, everybody, for joining us today. We're going to get started with our panel discussion on the Vanishing Trial documentary. My name is Lucian Dervan. I'm a law professor at Belmont University College of Law in Nashville, Tennessee, and also serve as one of the co-chairs of the American Bar Association Plea Bargaining Task Force. Let me thank first our hosts tonight, FAMM and the NACDL, who created an incredibly powerful documentary that I hope you were able to watch. I rewatched it again earlier today, and it's just a very compelling example of the way that criminal justice works today. I also want to thank our hosts and sponsors and participants today, the American Bar Association Criminal Justice Section, the Belmont Criminal Law Journal, the Belmont Criminal Law Society, and we're joined by our panelists who are representing Rutgers Law School, Georgia State University College of Law, and Harvard Law School, Thea Johnson, Russ Covey, and also Jonathan Wroblewski. So I'm going to start things off today just by sort of offering some reflections on the film. And we're going to kind of go around and just talk a little bit about something that struck us about the film and also relate that a little bit to some of our research and interests in this area. So I thought that I might begin just by talking for a moment about something that in particular struck me about this documentary, and that is the sentencing differentials that we saw in the various cases. In Eric Wyant's case, he was offered 3 years, received 20 years when he went to trial. Chris Young offered 14 years, received life without parole. Sandra Avery, 10 years and then eligible for parole, received life after trial. And those sentencing differentials, as I think you'll hear today from our various panelists, are key to the discussion about how plea bargaining operates and the kinds of incentives and the effect of those incentives in our modern criminal justice system. I thought in kind of reflecting on how unique this system is that we have today with these incredible incentives to plead guilty, I thought I might reflect back for a minute related to some of my research about the history of plea bargaining. You know, today, 97 to 98% of federal convictions come from a plea of guilty. About 95% or more of state convictions come from a plea of guilty. And at least in the federal system, we know that around 75% of those pleas are the result of an offer of leniency or a threat of further punishment if the defendant doesn't accept the offer. So given the staggeringly high percentage of cases that are being resolved through pleas of guilt today, one might imagine that this is an old system with deep common law roots that's been around for a very long time. But in essence, nothing could be further from the truth. This is actually a relatively modern American invention. It first began to be seen around the time of the American Civil War. At that time, courts struck it down uniformly as impermissible, in part because if you actually go a little bit further back in the common law, these types of inducements and incentives to plead guilty were explicitly found to be improper and coercive. It then began to come back into the forefront of American legal history in the early part of the 1900s. And it did so for two reasons that I think are really interesting as we think about the advent of the modern criminal justice system, which really does rely so heavily on plea bargaining. So from that time when we saw the common law reject plea bargaining, we then saw the American courts reject plea bargaining in the latter part of the 1800s. By the early 1900s, a couple of things had happened. One, plea bargaining had become a tool of corruption at that point. So if you look back at some of the larger city courts at that time, there would be, for example, in Chicago, someone called a fixer who would stand in front of the courthouse and they would literally sell sentences for bribes. The more money that was given, the lower the sentence would be, and then the money was divided up amongst the various parties who were part of the system, and that was considered some kind of bargain, not certainly a bargain as we would think of it today, But again, if we think about those early roots, that's where some of this begins. We then move just a few years further into our history, and we see the era of prohibition. We see us beginning to move into an era of what we might call overcriminalization, with new statutes on the books, many more people entering the criminal justice system than ever before. And the result is simply an overburdened system where there weren't enough prosecutors, defenders, judges, courtrooms, courthouses to take all of these cases to trial, as would have been more common further back in our legal history. And so this is when we begin to see the advent of sort of the modern plea bargaining system. It grew gradually, but interestingly, it grew in the shadows. And so prosecutors and defenders, judges, courts, they began to turn not to the corruption that we were seeing in the early 1900s, but to a legitimate form of plea bargaining, where incentives would be offered. And this was used as a mechanism to move cases more swiftly through the system, to reserve resources so that those cases that did want to proceed to trial could do so. And the system could continue to move forward, even as we began to have more and more cases on the docket. If we look to see what was going on at the same time as this sort of evolution and growth of plea bargaining in the shadows of the American criminal justice system, we would see that the higher courts, the appellate courts, were not that involved. And they were certainly not becoming involved in a way that would lead us to believe that the earlier precedent from the English common law or from the 1800s in the United States was no longer consistent. That earlier common law that said you can't engage in plea bargaining because it's impermissibly coercive. And there's a number of interesting cases in the appellate system that sort of go back and forth on this issue over time. But one of the sort of watershed moments that you'll hear people talking about with regards to plea bargaining happens in 1970 in the case of Brady versus the United States. And in this case, the Supreme Court was sort of asked to finally weigh in. Is plea bargaining permissible, or is the older common law, the older precedent applicable? And this is an impermissible system that needs to be stopped. Now, one of the fascinating pieces of history here is that by the time the Supreme Court sort of weighed in on this issue in 1970, there were already 90% of convictions in the US system coming from pleas of guilt. So, while the courts sort of sat by and watched to see what was happening, plea bargaining came to dominate from that growth in the shadows. And I really think by the time 1970 rolls around, the Supreme Court really had no choice in the matter. If they had struck down plea bargaining as unconstitutional, I think certainly the system would have collapsed essentially. So they said, you can do plea bargaining. We can make this part of our system. But there's what I think is a really fundamental caveat towards the end of their decision. And at the end of their decision, they talk about innocence, and they talk about the incentives to plead guilty and what they sort of envisioned for a plea bargaining system. And one of the things they envisioned was that there wouldn't be a need for excessive incentives because plea bargaining would really be used for individuals who had little chance of success at trial. And it would be a benefit for accepting responsibility and assisting with the efficiency of the system. And in doing so, it would preserve a lot of resources for those cases that did proceed to trial. And this was particularly important, I think, in 1970, because we had just finished the due process revolution of the Warren Court, and we knew that trials were taking longer in that period because of the new rights and new processes that had been created and observed. So the second thing the court said is, we are going to take a step back, though, and say, we would have concerns here if we thought that the incentives to plead guilty might lead an innocent person to falsely condemn themselves. But went on to say sort of they didn't really see that happening. They didn't have any proof of that. They hadn't really dug in on research. There really was none. But their inclination was to say that the guilty will use this as a benefit. It won't be a huge benefit, and it doesn't need to be. And the innocent, they'll proceed to trial. That seemed to be in the Supreme Court's mind what made sense. And that kind of brings me back to those incentives that I was talking about earlier when I was reflecting on the trial penalty, some call it, or the sentencing differential, which is commonly described as by academics. 3 years versus 20, 14 versus life without parole, 10 years versus life. Those are not small incentives. I do not believe those are the kind of incentives the Supreme Court envisioned in 1970. And I also think that those are exactly the kind of incentives that might lead an innocent person to falsely plead guilty. We saw in the documentary examples of individuals who stood fast and proceeded to trial despite the incredible increase in penalty that would result if they lost. I think we should also reflect on the many people who do not proceed to trial because of the costs associated with the sentencing differential, with the trial penalty. Some of the research that I engage in is psychological research to try to ascertain just how likely it is that an innocent individual might falsely plead guilty. And in our research, we found that participants in our psychological studies, around 50% of the individuals will falsely plead guilty in our study in return for the benefits of a plea bargain. It's a staggeringly high number, and I have to always ask, would the Supreme Court have ruled the same way in 1970 had they known that this is how we respond to these kinds of situations? This is how we respond to sentencing differentials. Sometimes we believe the most rational thing to do is to falsely plead guilty to something we haven't done because the benefits outweigh the risks of proceeding forward. In some new data that we've just released in a new piece regarding false pleas of guilty and psychological studies, we also found that in this new study, we sort of went one step further and said, to get the deal, you not only have to plead guilty yourself, you also need to agree to testify against the other individual who's been accused. We found that about 50% of the people who falsely pled guilty were also willing to falsely testify against their co-defendant. So this really begs the question, I think. What has plea bargaining done to our system? In return for efficiency, what have we done to accuracy? And what does the future look like as we begin to learn more and more about how the plea bargaining system operates, particularly given that it did grow up in the shadows, for most of its existence unregulated, unchecked. And I think the truth is that really it's only been in the last decade or so that we've started to take a hard look at what plea bargaining actually looks like, how it really works, and what the psychological impact is of these innocence issues, and begun to think about maybe it is time for more regulation, for more reflection on what the plea bargaining system would look like if we could start again. So with that little bit of sort of historical background on the issue, let me turn to Professor Covey, who's going to talk a little bit more about the issue of innocence and exoneration and this issue of what are the inducements to plead guilty. Professor Covey. You're still on mute.
That's part of my presentation right there. I just want to thank Professor Dervan and Belmont University for hosting this event and an opportunity to comment on an important film which addresses a really critical issue in criminal justice today. As Professor Dervan's comments suggest, the problem of plea bargaining directly affects not only those persons who are charged with crimes, but those people who are innocent of the crimes for which they have been charged. And the potency of the so-called trial penalty or plea discount or sentencing differentials, however you want to put it, is clearly significant enough to cause innocent people to enter guilty pleas. As Professor Dervan mentioned some of his research on sort of the psychological effects of those penalties. I've also conducted some research of an empirical nature on using the National Registry of Exonerations database of persons who have been exonerated and as the basis. And I wanted to share some of those results if I can. I'm going to try to share my screen here and we'll see what happens. All right. So waiting. So the study that I'm in the middle of is entitled "Measuring Plea Discounts for the Exonerated," and the study is based on the NRE database, which as of this morning had recorded 2,754 exonerations. And of those 2,754 exonerations, that is innocent people who have been formally acknowledged as to have been wrongfully convicted. Of that number, 569 are people who pleaded guilty. When I commenced this study, there were 512 persons who had pleaded guilty, and the data that I'm going to discuss is derived from that smaller number. But give you a sense of who these guilty plea exonerees are. The vast majority of the group are people who pled guilty to drug offenses. And I think that the reason why this number is so great is because of the various mass exonerations that have occurred periodically, including the Rampart and the Tulia cases, and the Sheetrock case in Texas, and some others in which large numbers of persons who otherwise probably never would have been exonerated were shown to have been part of sort of large groups of people who were wrongfully convicted and pled guilty. Of the individual criminal offenses, homicide crimes are the biggest chunk after the drug cases. And it's the homicide cases that I'm going to focus on here initially. And I think that the first thing that jumps off the page when you look at the data is that almost half of the innocent persons in the NRE database who pled guilty wrongfully faced possible death sentences, and they pled guilty to avoid a death sentence. That's a staggering sum, and it has a ripple effect throughout the criminal justice system. Christopher Ochoa, for example, pled guilty and was sentenced to life. He was exonerated in 1982, one of the first persons to be exonerated in this modern DNA era. Fred Steese pled guilty to avoid the death penalty. He was instead sentenced to life without possibility of parole. He was recently exonerated in 2017. Sean Worrell pled guilty to avoid the death penalty and was sentenced to 60 years in prison. He was exonerated in 2015. Not everyone in this group was confronted with a potential death sentence. Larry Williams was innocent but pled guilty to avoid a life without parole sentence and ended up getting sentenced to 10 years in prison. What this data suggests is that the plea discounts in these cases are enormous, and that was a point that was clearly made in the film as well. The data that I've looked at in the homicide cases suggests that plea sentences on average are about a third of the potential trial sentence maximum, and are smaller by a significant amount than even the minimum sentences that would be otherwise imposed had the defendant been convicted at trial. These enormous plea discounts are incredibly coercive. Consider Donald Heiston's case. Donald Heiston was facing a life sentence, and instead he pled guilty to being an accessory after the fact and received a sentence of 3 to 5 years, which accounts for about 8% of the potential maximum sentence that he would have or could have received had he gone to trial and been convicted. There is no doubt that a discount of that magnitude is coercive, in my view. The NRE database is full of similar kinds of cases. People who were charged facing first-degree murder charges, life sentences, bargaining that sentence and conviction down to manslaughter, 6 or 7, 8 years, which are, again, just a tiny fraction of the potential punishment that they otherwise would have faced had they gone to trial, as did the defendants in the film. I also have done a little bit of research into the sexual assault cases. There are fewer of them in the NRE database involving individuals who pled guilty. But of that group, it's about 20. The average sentence that was received as a result of the plea bargain was about 22% of the possible maximum sentence that they would have faced had they been convicted at trial. So this is at least double the size of the benefit that defendants in homicide cases are getting. Brian Banks may be familiar to you from the film that was made a couple of years ago about his case. He was charged with rape as a teenager and faced 41 to 50-year sentence. Ultimately, he pled guilty, was sentenced to 6 years in prison. It's 12% of the potential sentence that he otherwise might have served. Brian was exonerated in 2012. A man named Larry Bostic similarly faced a sentence of 50 years, pled guilty, was sentenced to 8 years, right, so 16%. And there are numerous similar kinds of cases. The last type of case that I just wanted to briefly touch on are the drug cases, which, as I said in the beginning of my remarks, make up the biggest chunk of persons who plead guilty and then are exonerated in the database. We have not yet had an opportunity to thoroughly analyze the differentials in the drug cases, but I think it's undoubtedly likely that the differentials will be even larger than those that appear in some of these, in the cases that I've discussed so far. And just to take an example from some other research that I have done based on the Tulia, Texas cases. In Tulia, around 2000, there was a scandal which led to the wrongful conviction of 37 innocent defendants of various drug crimes. Of that group of 37 people, 7 went to trial and 30 pleaded guilty. And the differentials in those cases were, not surprisingly, given what you've seen, shocking. In the trial cases, the average trial sentence was 51 years. In the 30 cases that followed, and everyone after the first 7 pled guilty, the average sentence was about 4 years. That's a differential of 1,300%, and is undoubtedly, right, coercive. So my takeaway from this data, from the film, and from everything else that I know about the criminal justice system is that there are certain kinds of plea bargains that are simply inherently coercive, and bargaining over the death penalty is one of them. Bargaining over life without parole sentences is another. And that enormous trial penalties can always be coercive. And the magnitude of that trial penalty has to be measured both in terms of magnitude, sort of comparison of the differential, but also in terms of the years and, in many cases, decades of additional punishment that is being threatened to be imposed on defendants who go to trial. All right, with that I will stop sharing and turn things over to the next speaker.
Thank you, Professor Covey. Before we turn to Professor Johnson, I just wanted to note for those participating, we look forward to taking your questions after our opening comments here. If you look at your screen, there is a Q&A section, and you can post your questions directly to the panelists there, and we'll keep a lookout for those. With that, I will pass it to Professor Johnson, who's going to talk a little bit more about the ways that the sentencing differentials, the trial penalties, can impact various areas in the criminal justice system.
Great. Well, thank you so much. And I'm really pleased to be here. So thank you to all the many hosts and to Belmont Law School. And I think my comments today will build on the comments we've heard already. I'm Professor Thea Johnson, professor at Rutgers Law School, also the reporter for the Plea Bargain Task Force. And like the rest of the panel, deeply invested in these issues of plea bargaining and what they mean for the fairness of the criminal justice system. So I want to spend a little bit of time in my response talking about the ways in which the trial penalty has shaped the practice of plea bargaining. Of course, the practice of plea bargaining has been shaped profoundly by the trial penalty, and as I'll discuss, other mandatory consequences that are now in place when one is convicted. So it's important to understand that there's no magic formula for what the plea offer will be in any given case. There are certain concrete factors like the seriousness of the charge, the potential sentence, but there's lots of other things that are intangible that shape the plea offer: the relationship between the parties, the defense attorney and the prosecutor, who the judge will be that day in court, the policies, both unspoken and written, of the prosecutor's office. And while there is often a consensus about what is a standard offer in any particular jurisdiction, the practice of plea bargaining is quite hard to pin down. And the other reason it's hard to pin down is for all the reasons that Professor Dervan talked about. Plea bargaining doesn't have this long history, but even if we were to look since the 1970s, the practice of trials actually has been litigated in courts, particularly the Supreme Court, and we have a deep well of case law about how trials should work. We don't really have that much case law, particularly at the Supreme Court level, about plea bargains. That's changed some in the last few decades, particularly in the area of ineffective assistance of counsel. But mostly plea bargaining is a fairly unregulated process, unregulated by the courts, unregulated often by local legislators. If you look at the rules of criminal procedure in any given jurisdiction, again, you're going to have many fewer rules about plea bargaining than you are going to have about trials. So I'll get back to why I think that's important, sort of the unregulated nature of the market in plea bargaining. But of course, what you saw in the film is that plea bargaining is intensely bound up with mandatory minimums. And I just want to note that mandatory minimum sentencing is just one of many mandatory outcomes that defendants now face in the criminal system. So the defendants also face a range of mandatory collateral consequences, like sex offender registration. They also, as I'm sure many of you are aware, face certain mandatory consequences if you're a non-citizen, mandatory immigration consequences as a result of a conviction. And so if you have, let's say, a hypothetical non-citizen defendant, and of course this isn't a hypothetical, this happens every day, non-citizen defendant who is charged in a sex crimes case, that defendant may be facing a mandatory sentence, a mandatory sex offender registration, and mandatory deportation. And so, what does all this mean in an unregulated plea market? And not surprisingly, what it means is that all these mandatory outcomes really shape the behavior of the parties at plea bargaining. And what I am interested in is how those mandatory outcomes shape people's behavior in ways that might surprise us, might upset us, might make us ask, what's the purpose of the criminal justice system? So some of the things that I have looked at are the ways that people try to negotiate around these mandatory minimums. We have, an issue of vanishing trials. So of course, most people don't go to trial. Most people plead guilty. And most defense attorneys are in the business of trying to negotiate around these minefields, these mandatory sentences and other consequences. So some of the things you see in the modern day court system, courts signing off on defendants pleading guilty to crimes that everyone agrees the defendant did not commit. Courts signing off on defendants pleading guilty to crimes that don't exist in the statute books. So for instance, lots of defendants pleading guilty to attempted involuntary manslaughter, which is simply impossible to be convicted of because you can't intend to do this reckless thing. And if you're in my criminal law class, I see some of you here, you'll learn about that by the end of the semester. I'll test you on that. So courts also regularly approving of plea decisions where the parties have negotiated over the facts in ways that make the facts, they have a passing resemblance to truth, but mostly totally disconnected from truth, right? What ends up in the charging document or the indictment, largely disconnected from the defendant's actual conduct. And the reason why prosecutors and defense attorneys negotiate around these things, or why they create these pleas, is so that they can avoid many of these mandatory consequences that the defendant would face if the defendant went to trial and was convicted, or even if the defendant pled guilty to the top charge. And so I'll just note this as sort of my closing point, but I'm co-authoring a paper right now about plea bargain decision-making for non-citizens, and sort of thinking about plea bargaining through the deportation lens. And what's interesting to me about the cases that I'm seeing is just how much the trial penalty is cemented in the thinking of courts. So for those of you who don't know, there's a very important Supreme Court case called Plea. And in the Plea case, the Supreme Court held that a defendant can bring a successful, ineffective assistance of counsel claim against his lawyer if the lawyer fails to advise him that there was a deportation consequence to his plea, to his conviction. In later cases, the court makes clear that the defendant has to demonstrate prejudice as a result of the defense attorney's failure to give correct advice. And so what are courts looking at when they're trying to determine if the defendant was prejudiced by his lawyer's bad advice? Well, one of the big things they're looking at is what would the sentence have been after trial? So they asked the question, if the defendant had decided not to take this plea and instead had decided to go to trial, what would the potential sentence have been? And not surprisingly, many times the potential sentence is incredibly lengthy. And so in this way, courts are pitting the deportation consequence against the trial penalty consequence. And generally where the trial penalty or where the potential sentence was very high and the plea on the table was very low, courts will find that the defendant cannot make out that he was prejudiced by his lawyer's poor advice, right? And what I find so striking about these cases is that the rationality of the trial penalty is never really questioned. The trial penalty is really normalized through these cases, through these decisions, and made part of the rational calculation of plea decision-making, which I get, right? It is part of the calculation of plea decision-making. But I think it's also a real demonstration of where the criminal system is, right? We have defendants, some of whom are not charged with particularly serious offenses, charged with often drug offenses, been in the country their whole lives. And the question is, what's worse, to spend the rest of your life potentially, or decades in prison, or to be deported from the only country you've ever called home. And to me, that's a pretty disturbing place to be. And the final point I'll just make is one of the key features, I think, that these cases that are pitting the trial penalty against deportation leave out is just how much lawyering goes on, right? And we miss a lot of this lawyering. So Professor Dervan mentioned, a lot of this happens in the shadows, and it still happens in the shadows. And there's tons of lawyering that's happening where lawyers are trying to avoid both the trial penalty and potentially the deportation consequence. And courts have largely just not touch that. They don't want to touch the actual lawyering that's happening on the ground or do anything to regulate it. It's sort of seen as an art, and we leave it to the lawyers. But as a result, something is missing from this conversation about the responsibility of lawyers here, to help people avoid what is often really terrible outcomes. So I'll leave it at that. Thanks.
Thank you, Professor Johnson. We'll now turn to Professor Wroblewski, who holds many hats. He not only teaches at Harvard, but is also the director of the Office of Policy and Legislation in the Criminal Division of the U.S. Department of Justice, and has previously been a state prosecutor. So he's going to share with us a little bit of some of these varying perspectives. What does it look like at the state court system? What does it look like at the federal system? And sort of allow us to sort of dig a little deeper into what plea bargaining looks like in these various stages and jurisdictions of our criminal justice system. Professor Wroblewski, please take it away.
Thank you. Thank you so much. Everybody can call me Jonathan, and Professor Dervan, you got one thing wrong. I was a public defender in the state level, and I'll talk about that in a little bit. First of all, thank you to William and Brian for your questions. Here's the very quick answer, and then I'll give my presentation and maybe give a longer answer. Yes, plea bargaining, the problems with plea bargaining is the symptom, and there are other problems. Yes, it will have to be solved by legislation, but no, that will not be sufficient. I'll talk about that some more. Thank you to everyone at the Belmont College of Law, to Professor Dervan, also to the folks at FAMM. I got to know Kevin Ring and Mary Price, who were both featured in the movie. And just a quick shout out to Julie Stewart, who was the founder of FAMM, an extraordinary person, and the organization, extraordinary organization. So what I thought I'd do is I just tell three stories. No big deal, three stories that influenced my thinking about plea bargaining. And the first story starts in August of 1986. It's a long time ago. And I can't see any of the students, just so you know, I'm staring at the same 6 boxes that probably all of you are. But I'm assuming that some of you were my age, or I was your age back then in August of 1986. I had just graduated from law school. I had just taken the bar exam, and I had just accepted a position as an assistant public defender in the Alameda County, California Public Defender's Office. Alameda County is the east side of the San Francisco Bay. It's Berkeley, it's Oakland, it's Hayward and Fremont, the city of Alameda. It's a really interesting place. Back then, if you took the bar exam in July, you didn't get the results back until November. And so at that time, between August and November, I was assigned to the Oakland courthouse to work on a case with a number of other lawyers, the case of People versus Anthony Wimberly. Now, Anthony Wimberly was also about your age at the time, and he was charged with several counts of murder, with several counts of attempted murder, several counts of rape, several counts of robbery. And when I got on the case, it was really interesting. Everyone knew that Mr. Wimberly was going to spend the rest of his life in prison. I was asked to be part of this team that was going to be doing the mitigation work, which means looking back at Mr. Wimberly's life and finding out why he ended up in the situation that he did. Now, why did everybody know that he was going to spend the rest of his life in prison? Well, Mr. Wimberly, when he was arrested, admitted to all the crimes for which he was charged. But not only that, several of the women that he had shot and did not kill readily identified him. And not only that, his fingerprints were found at the crime scenes. The bullets that were pulled from the victims that he killed matched bullets that were shot from the gun that he was arrested with. The case was over, there was overwhelming evidence against him. And there was no plea offer and there was no plea bargain. The prosecutor was seeking to impose the death penalty. The crimes occurred in 1984. Remember, I got on the case in August of 1986. Mr. Wimberly went to trial in 1989. He was found guilty of all counts. The jury hung on the issue of whether he should get the death penalty or not. And Mr. Wimberly tonight is a 58-year-old man, and he's in Mule Creek State Prison in California. Now, during the time from 1984 until the appeals were concluded in the early 1990s, the state of California and the county of Alameda spent millions and millions of dollars on the case. The victims were forced to testify and to relive horrible, horrible moments in their lives. Tens of thousands of man-hours were spent on the case. So that's story number one. Story number two, fast forward to December of 1986. And miraculously, I passed the bar exam. Okay, so you can all stand up and cheer. And I was assigned to a municipal court in Hayward, which is about 20 or 25 miles south of Oakland. And what I found in municipal court in Oakland was a marketplace. Hundreds and hundreds of cases being litigated, misdemeanors and felonies. I represented hundreds of people during that time, and there were bargains to be had, bargains everywhere. Now, in that courthouse, in those cases at that time, there were very few mandatory minimums. There were no sentencing guidelines of any kind, but people in the courthouse knew what cases were worth. So for example, back then, to be convicted of drunk driving, you had to have a blood alcohol level over 0.10. I know it seems crazy now, but that was actually the case. And everybody knew that if there was a breathalyzer test and somebody blew 0.11, that was not going to end up as a drunk driving case. It was going to end up as a reckless driving case. And people knew if there was a blood test and somebody had 0.20, that was going to be a drunk driving conviction. And they knew what the penalty was going to be. And there was no appreciable trial penalty in most cases, nothing like what was depicted on in the movie. Most clients also, when we interviewed them, most clients admitted their guilt. When we just asked what happened, they told us what happened, and most clients admitted their guilt. Also, most clients wanted the case over as fast as possible. Rarely did anybody want a trial. Some did. Some wanted a trial, and some wanted to litigate a search and seizure or other motions on our recommendations or otherwise. And with serious felonies, we wanted as lawyers to have a preliminary hearing in most cases so we could hear the evidence and see at least some of the witnesses. And as a result, most misdemeanors pled guilty. Around half of felonies pleaded guilty. Most pleaded later. The ones that wanted a trial had a trial. And the ones who were convicted after trial got a sentence roughly the same as what they would have gotten if they had pled guilty. The ones that went to trial did not get a sentence, many times the plea offer, as was depicted in the movie. This was the culture of the courthouse, and this was the marketplace that I saw. Now, fast forward another few years until the 1990s, and now I moved to Washington, D.C., and I joined the Civil Rights Division. Now I am a prosecutor, Professor Dervan. I am a prosecutor, and I'm in federal court. And federal court is very, very different. At that time, there were mandatory sentencing guidelines. There were mandatory minimum sentencing statutes. And there was much less volume except for the Southwest border districts. Again, I was in the Civil Rights Division, and I just want to tell you about one case I had early on. It was the case of a woman who lived in Cordele, Georgia, which is just south of between Macon and Albany, Georgia, south of Atlanta. Her name was May Jo Lester. And she was a woman who took care of foster children for her livelihood. And she wanted to move out of a double wide trailer and move into a single family house. And she did with her children. She bought a small little frame house on the outskirts of Cordele. And not long after she moved in there, a cross was burned in front of her house. And not long after that, her house was burned down. And when the local sheriff came, they didn't identify any perpetrators. When the Georgia Bureau of Investigation came, they didn't identify any perpetrators. And we went down there and we invested the case. And we identified 4 men, 2 who were involved in the cross burning, 2 who were involved in the arson. And then it was time to write up the charging document. And when we wrote up the charging document, I looked at the statutes, and there's a statute called the conspiracy to violate civil rights at 18 U.S.C. 241, has a 10-year statutory maximum penalty. There was a violation of the Fair Housing Act, that's entitled 42. It had a 1-year maximum penalty. And then I was told by my colleagues that there's this other statute, 18 U.S.C. 844H. And it said that if you use fire in the commission of a felony, there's a mandatory minimum add-on of 7 years. And so we added that to the people who burned the house down, but it seemed odd to me that we would add it to the people who burned the cross in front of her house. It seemed like that was an excessive sentence. And I spoke to my colleagues, I spoke to my bosses, and they said, put it in the indictment. And if they're willing to plead guilty, you can drop that charge. Now, remember, this was the Civil Rights Division. Okay, these are the people who are my bosses. So that's the third story. And what are some of the lessons that I take away from all of this? My lessons is that, number 1, plea bargaining is not inherently bad. Number 2, most criminal cases should not go to trial. Number 3, mandatory minimums and some forms of mandatory sentencing guidelines distort the process and often can greatly distort the process. And number 4, court culture matters. Regardless of whether you have the legislation, the mandatory minimums, the guidelines, or otherwise, culture matters, including the views of the judges. It's not just the prosecutors. And so with that, I just want to conclude by saying that I share Kevin Ring's desire, which was expressed in the movie, to reform the criminal justice system, to make it more just. And I think there's plenty of room to do it in the system that I work in, which is the federal criminal justice system. And I'm honored to be working with my co-panelists on the ABA plea bargaining task force and in other positions where we hope we can bring about some of those reforms. That's it, Lucian.
Thanks, Jonathan. I think that's a great way to end sort of our initial discussion because, we've alluded to it, but I don't think we've explicitly said it. All of us who are appearing here tonight serve on the ABA Criminal Justice Section Plea Bargaining Task Force and appreciate the nuances to the plea bargaining system. I won't speak for everybody, but I, for one, agree with Jonathan that there is a place for plea bargaining in my mind. The question is, how do we best do it? How do we regulate it in a way that it hasn't really been regulated before to try to enhance its use in the ways that are effective and limit the ways that it can be coercive. And so I appreciate Jonathan's comments bringing us those various perspectives, including as a public defender, to our conversation. And I think it does lead right into, we've got some questions coming in, so I hope that everybody will keep posting questions there and we'll try to get to as many as we can. But I think it does lead directly into one of them. And Jonathan, began to answer it, but I think as a group, we should come back and talk about this one a little bit more. The question is about whether plea bargaining is, it says, the disease or a symptom. And, as members of the plea bargaining task force, I will tell you that we, for fun, because we enjoy this stuff, we sit around for hours and hours on the weekends together on Zoom. And before that, we used to go to DC and sit around for the entire weekend for 10-hour days and talk about how we can make the system better. And this is one of the things we keep coming back to over and over again. And that is, plea bargaining is a way to address some of the systemic problems in our criminal justice system. If you were to do away with plea bargaining today, because of some of the things we're talking about here that we think need to be reformed in the plea bargaining system, I think the system would be much, much worse than it even is now. And so the question that we keep grappling with is, when we're proposing, and we will be proposing shortly through our report, reforms of the plea bargaining system, we feel like we need to be really careful, because some of the things that plea bargaining allows you to do is to overcome some of the injustices in the in the criminal justice system more broadly. So I won't go any further, just to kind of tee that up a little bit for the group here, and I'll throw it back out to my other panelists to sort of weigh in on this issue of how do we deal with a plea bargaining system that is in some way helping us overcome some of the other problems in our criminal justice system. How do we kind of wrestle with both of these things at the same time? How do we make the whole system better, with plea bargaining being just a part of it?
I can start. The problem, in my view, is, as has been acknowledged by an authority no less than the United States Supreme Court itself, that plea bargaining is the criminal justice system at this point. So, when you talk about 95+% of criminal convictions resulting from guilty pleas, you can see we're talking about the entire system. And so to reform plea bargaining means to reform the entire system. So everything is interconnected. So it's once you start pulling a thread, lots of different things unravel. I mean, I certainly agree with Jonathan that there is a place for plea bargaining in the system that we have, if balance is maintained. But we've gotten to the point where our system has serious imbalances, including imbalances in the extent of discretion that is available to prosecutors on the one hand, and judges on the other, who oftentimes, because of these mandatory minimum sentences and other provisions of the criminal code that Professor Johnson was talking about, make it almost impossible for judges to weigh in and think about a case in terms of justice, as opposed to simply what they are required to do, given the charges that are on the books. So I think that the solutions have to be holistic, and everything is on the table.
And I would just add that, and by the way, Brianne, thank you for your question, and Will also. I think, to me, it's the symptom, and less than it's a representative of the disease. And some of the Rutgers law students here may have attended in the fall semester. I was on a panel on plea bargaining and racial justice, and somebody in the panel said, well, we get hundreds of thousands of misdemeanors coming through Newark every year, so if without plea bargaining it would all fall apart. And my response then, and it's always my response, is, well, why do we have hundreds of thousands of misdemeanors coming through anywhere, right? Big city, small city, plea bargaining makes that possible. You can sort of have this incredible churn of cases. Why do we have this incredible churn of cases? Over criminalization, just a huge number of criminal laws that you can be arrested for. It's the criminal code, but it's all sorts of violations. It's all sorts of, when I used to teach in Maine, I would joke there's a whole section of the hunting code that's criminalized and you can arrest people for. And then, of course, mandatory minimums. I think, outrageous sentences, particularly mandatory minimums, to Will's question, to me, that would be the number one thing. If you had a magic wand and you could fix one thing tomorrow, there are a million things I'd fix, but I think mandatory minimums would be the first thing. And that's, of course, legislators can do that. Because if you get rid of that, that's a big step towards eliminating part of the problems we've been talking about today.
Jonathan, do you want to weigh in a little more on this one?
I think there are just lots of, I think it's definitely the symptom, it's not the disease. And I think that I've seen it work in a way that did not seem unjust in most cases, did not pressure people to plead guilty where there was room for trials. And I've seen it work in ways that are almost patently unjust. And so I think you have to try to craft a system that will work, that will create justice, that will not put undue pressure on anybody, and that will also, frankly, move a case along so that the case can actually be resolved in a reasonable amount of time. So I think there are many things that can be done legislatively. I think there's a lot. But I also, as I said before, I think a lot of it also comes down to culture and accepting the fact that a trial is not something to be avoided, that if somebody wants a trial, okay, let's go have a trial. And we can do it in a reasonable amount of time and without a crazy expense, and it won't necessarily bring the whole system to a halt.
Yeah, I'll just agree with what's been said and also echo mandatory minimums are a huge part of the problem, and that has to be addressed to correct our criminal justice system as a fundamental starting place. But I'll also say that I do feel like there's a symbiotic relationship between overcriminalization and plea bargaining. If you look at the historical development of each, they really have relied on each other to come to dominate the way that they have. I mean, we've alluded to the fact here, we have somewhere around 4,500 federal crimes in the US Code, could be more at this point, 300,000 plus regulatory offenses that are really impossible to identify. Jonathan kind of talked about this idea of choosing offenses. And that's really one of the ways that plea bargaining is been allowed to thrive, is that there are so many different crimes that you can select from for the same conduct, each carrying different penalties, some carrying mandatory minimums, some not, that it's not difficult at all to create the trial penalty that we've been talking about. At the same time, if you sort of look at cases where people had an opportunity to challenge the system, to challenge the size of the differentials, to challenge the way that it sort of takes away their choices and leads innocent people to plead guilty, there's just not many of those cases that go up on appeal, because who would take that chance? Most people do what we've been talking about, which is they take the deal that's been offered. They don't appeal their case all the way to the Supreme Court in hopes that the court will sort of see what has happened to them. But if they lose, they spend the rest of their life in prison. If they had taken the deal, they could be at home by now. And that's just, I think, part of the reality of the system. So overcriminalization is shielding plea bargaining from review. And at the same time, plea bargaining is made possible by overcriminalization itself. So there's this incredible relationship between the two. And that's why I think at the end of the day, you have to address both at the same time. We're not going to be able to do this by doing only one. I think another question I see here on the list, I'll ask Russ to weigh in first, because I know that Russ has talked about this specifically. The question is, do we have ideas for legislation to deal with the trial penalty? Again, just to allude back to some of the conversations we've had on the task force, we've talked about this for hours and hours. What do we do about the trial penalty? Is this for the courts? Is this for the legislatures? Is this an issue of the culture of the legal institutions? And is this an ethical issue? I think the answer from my perspective is it's all of these things. But I know Russ has some specific thoughts on proposals. So do you want to weigh in on that a little bit, Russ?
Yeah, I can try. This is an incredibly difficult issue, for some of the reasons that I have already suggested. It's such a big problem. But in my view, the aspect of our criminal justice system that really needs to be reformed is the tolerance currently of the sentencing differential. I mean, the policy was set on high from the United States Supreme Court in a case called Bordenkircher back in the late 1970s, when the court considered a case in which the defendant had been offered a 5-year deal in a $85 check, the forged check allegation. And he may have thought that 5 years for an $85 forged check was excessive. And so he wanted to take the case to trial. The prosecutor amended the indictment and he was charged under the Habitual Offenders Act, facing a mandatory life sentence, and he was convicted. and he served a life sentence. The Supreme Court held in that case that the prosecutor's act of threatening to bring the mandatory life sentence was not unduly coercive, because that sentence was lawfully authorized under the statutes at issue. That may be true, but the sentence, I mean, the fact that it was an authorized sentence, but the effect was clearly coercive. Our criminal justice system has adapted to this idea that these enormous, threats of trial penalties are just part of the game. And so any kind of reform needs to, in my opinion, rethink that idea. The existence of these huge differentials are, I think, inherently coercive, and they distort all sorts of decision making on the part of defendants, prosecutors, defense counsel, and judges. And so that's where I would start. And it's not simple to come up with ways to limit the differential because of certain essential ideas that we bring to the table when we talk about criminal justice, including prosecutorial discretion and the prosecutor's virtual divine right to decide what charges to bring and when not to bring charges. So that's sort of sort of a sacred cow that's on the table in this discussion. But it all needs to be rethought.
So go ahead.
I was just going to jump in on Bordenkercher and I think it's important to really draw out that you had the Supreme Court decision where the court put a stamp of approval, as Russ explained, on the original sentence was going to be 5 years. He turns that down to go to prison, to go to trial. And the sentence that he gets after trial is life in prison. And the court stamps approval on a life sentence on forging an $87 check. And I think we can't, it goes to Jonathan's point about culture and sort of how lawyers think about things. I think we should really see that decision, or my take on that decision is, it's one of the worst Supreme Court decisions there is, and it doesn't really get the attention it deserves. The court allowed this man to be sentenced essentially to, death in prison on forging an $87 check. And I know a prosecutor would say, oh, but it was his third felony. And I'll just note that his first two felonies, one was like a robbery, and the other one was when he was 17 years old. So we're not talking about a guy who had, multiple super violent crimes, and this was the tip of the iceberg that just sort of, pushed him over. And so I think, thinking about how the Supreme Court has played a role in fostering a sense that these practices are okay is also really important.
So I think there's a way out of this. I'm not as pessimistic or the reason that case works the way it does is because there's a mandatory minimum associated with the charging decision. No mandatory minimum associated with the charging decision. Who cares? Charge whatever you want. You want to charge third-time offender? You want to charge this? You want to charge that? I don't care. It's up to the judge to sentence. And so the structure of the system to me is absolutely critical. Mandatory minimums are part of it. Certain versions of sentencing guidelines are part of it. And then, like I say, culture. And I think if you address those pieces, which I think all are addressable. Adam asks in his question about you need 60 votes so nothing will happen. There's bipartisan support right this minute for getting rid of mandatory minimums. Are there 60 votes? I'm not sure. Is it to get rid of every single mandatory minimum? I'm not sure. But I think there is an opportunity right now to do something about, in the federal system, to do something about many of the mandatory minimums in the federal system, and to do something about the sentencing guidelines. So I think there's a way out of it. Overcriminalization, I'll be candid with you. I don't think that's a problem. I don't like the criminal code. I would love to reform and rewrite the criminal code. I've been an advocate for that for many years. But go into state court, go into a typical state court. Yeah, there are some things that shouldn't be crimes, like driving on a suspended license. But most crimes, even the misdemeanors, assault, drunk driving, theft. Yes, there are minor crimes that shouldn't be prosecuted, and many progressive prosecutors are creating policies that are diverting many of those cases. But it's not because the code is so large and things that, stealing shouldn't be a crime. So I don't really think overcriminalization is part of this problem. It's part of another problem, and that should be solved as well. But this problem, I think, is primarily mandatory minimums, sentencing guidelines, culture, all of which that can be changed with a little leadership and with some advocacy.
Thanks, Jonathan. So yeah, I was going to kind of answer one of those other questions too, because there was that question about, do we have the votes? Is there bipartisan interest in this? And I'll just say, to echo what Jonathan said, I think there is. And if you just look at the membership of the plea bargaining task force, it's a very diverse group of think tanks, academics, prosecutors, defenders, judges, both state and federal. I think there's a pretty wide-ranging recognition that there's a problem. I don't think everybody always agrees on exactly how to fix it, but I don't hear a lot of people saying that the plea bargaining system is exactly what we want. I think what we hear is there needs to be some reform here. There needs to be work done. And what we're doing as a task force is try to figure out what that looks like. And to just kind of finish up on this original question, I think it's going to be all different types of reform. I think that the courts are beginning to look at plea bargaining in a different way. And we've seen that just in the last decade from the Supreme Court. Russ was mentioning earlier, the Supreme Court saying in 2012, plea bargaining is the criminal justice system. That's just not something we'd ever heard from them before. In fact, I mean, for most of its existence, they really just ignored the plea bargaining system. So that in itself was huge. And if you look at the Lee case that came out a couple of years ago, really interesting language there from Chief Justice Roberts about what are people's determinative issues was the language used. What is driving people to plead guilty? And really, for the first time in that opinion, there's discussion of the fact that actually being guilty might not be the reason somebody pleads. There could be something else driving that decision. Now, we've all discussed that today. We know that to be true, but to actually see the Supreme Court begin to talk about that concept and to move away from this idea that, if you plead guilty, you must be guilty, to a more nuanced examination of there's a lot of reasons someone might plead guilty. And being actually guilty may or may not be the determinative issue that led them to that decision. I think that's going to be really significant going forward. So the courts are going to intervene, I think, at some point and weigh in more. The legislatures, I think, are going to weigh in more. We're seeing that kind of bipartisan support for addressing the plea bargaining issue. And then again, to allude to something I talked about earlier, one of the things we're talking about a lot on the plea bargaining task force is what is ethical? Not what can you do, but what should you as an attorney do? And that's going to be, I think, part of the discussion going forward as well. Let me take the next question and direct it first to Thea and see if you'd like to take this one on. There's a question in the chat here about how do we deal with this issue of people pleading guilty to something they haven't done? And I know you've done a lot of work on this idea of these false pleas. So I thought you might want to try to take that question a little bit and talk about this problem of people pleading guilty to things they haven't done and what that does with the system as a whole.
Yeah, absolutely. So, I mean, it's a similar answer to what we've been saying, eliminating mandatory consequences. And I think, as I noted in my remarks, mandatory collateral consequences are a big part of this story. So including immigration consequences, which I should say are not considered collateral consequences formally under Supreme Court precedent, but sort of, fall into that category when you're a public defender on the ground thinking about these things. Almost all drug crimes come with incredibly harsh immigration sentences or immigration penalties. And so if you have a non-citizen who is charged in a drug crime, they really can't plead guilty to that drug crime. And maybe that's the only crime they committed. Maybe that's, the facts only make out conduct that would meet the definition of a drug crime. And so what is that defendant supposed to do if they want to stay in the country? And oftentimes the answer is pleading guilty to something that their lawyer fashions, sometimes out of whole cloth, in order to avoid that consequence. You see it also a lot with sex offender registration. And in a prior piece I did where I interviewed a bunch of public defenders, I heard over and over again, you know, my client would rather trade a few extra years in prison to avoid being a sex offender. Again, sex offenses frequently, most felony sex offenses across the country come with mandatory sex offender registration. Sex offender registration, incredibly onerous. It impacts where you can live. It impacts how you can work. Of course, your neighbors can find out that you're on the registry. So there are a lot of reasons to want to avoid it. And as a result, again, people are willing to, you know, negotiate to other charges, you know, kidnapping charges, where really kidnapping is not made out in the true facts of the case. And so I think if you eliminated mandatory minimums, mandatory collateral consequences, mandatory immigration consequences, you would just see less of this, you know, massaging the case to the point of, you know, what I call them as fictional pleas, to the point of fiction. Although I argue in a piece that I just finished right now that, you know, there's actually lots of lying that we do in the system. We let people take Alford pleas where they say that they're innocent, even though we believe that they're guilty. Sometimes we let people take Alford pleas and say that they're innocent so that we can be done with the case, even though we actually do think they're innocent, but we're making them take a conviction. You know, the litany of questions that a defendant has to answer when they take a plea. They have to answer a bunch of questions about whether they're pleading guilty because they are guilty. And sometimes judges just allow them to answer those questions knowing that the answers are not true. So, you know, how do we get rid of it? I think in my mind, we have to get rid of all the incentives for making things up. And that starts with the mandatory consequences. But I think there are other things we could do as well.
Can I jump in, Lucian?
Jonathan, please.
Yeah, so two things. Number one, I really think we should try to avoid making things up and just accepting untruths as the system. I'm not saying we're going to eliminate them all, but I think we should do everything we can, including put on an ethical responsibility on both prosecutors and defense lawyers not to be lying to the court. And I'll just tell you, when I first became a public defender, one of the first things I was told is when you interview a client and you find out what happened, you're going to write on the cover of the piece of paper, because at that time there were folders and paper, and you're going to write on the cover, in the inside cover of the folder, D admits or D denies. And if it says D denies, and then you come forward and he says, I want to plead guilty, you have an ethical obligation to say, no, you can't, or we're going to have to have a talk about this. And we're going to have to get from D denies to D admits. Okay. You don't necessarily say it that way, but the idea is if he says no, you can't ethically go into court and say yes. And I think prosecutors need to really think very, very long about whether they want to charge offenses that they know did not happen. I understand they don't like the consequences of charging the offense that did happen, and the defendant doesn't like the consequences of what happened. But sometimes cases have to go to trial, okay? That's what a democracy is. You and I may hate this collateral consequence. That's the law. And I just think the lying, making that a regular part of our system, is worse than occasionally taking a consequence that we don't like and we would prefer that doesn't happen. So I think getting rid of the lying in the court, I'm not saying we're going to completely get rid of it. I understand that. I can't tell you how many pleas I was part of where a defendant was just saying yes, yes, yes to a series of questions in what in the federal system is called a Rule 11 colloquy, and he didn't really understand what all those things actually meant. So I know it's never going to be perfect, but I think we should at least strive for that.
Yeah, I just want to echo that thought as well. I mean, you know, when we think about what the criminal justice system is about, it's about doing justice to the individuals who are both accused and who have been victimized, but it's also about doing justice to the community. And part of doing justice means creating an accurate record of what happened. And if our criminal justice processes don't do either of those two things very well, right, do justice or create an accurate record of truth, then our criminal justice system is really failing on all fronts.
Yeah, I'll just weigh in a little there and say, one of the things that we've talked a lot about on the task force is transparency. And it's really something that we need in this system. And it goes to this issue of fictional pleas and lying. One of the things that I don't like to hear in cases where there's a plea is the judge ask the question, are you pleading guilty because you are guilty and for no other reason? And I just think that perpetuates the system in which we kind of cover up what's really happening, and we pretend that the person is there simply to plead guilty because they are guilty and this is their attempt at sort of, coming clean. What I think we need to ask is a completely different question when someone goes to plead guilty. I think the question should be, tell me what offer was made with regards to an inducement to plead guilty. Why are you pleading guilty today? Was there an offer of a benefit? Was there a threat of further punishment if you didn't take the deal? To me, that's a lot more interesting, because that would allow the judge to look behind the negotiations that have been occurring and get a much better sense for what's happening. And as Jonathan was alluding to, if you have someone who comes in and says, I'm pleading guilty because I'm going to get 2 years, and if I don't take this deal, I'm going to get 10 or 20, or we've seen some staggering numbers here today. I think a judge should know that, because if I was the judge, I'd dig into that case in a pretty significant way to see exactly what's happening. And if as Jonathan described, the defendant is just sort of nodding their head yes to the questions during the Rule 11, but they don't really know the substance, that should be grounds for the plea to not be accepted. And I just think that process of looking deeply into the plea and what's motivating it has been lost in a lot of ways in the way that the system currently operates. And I think shedding light on that is going to be really helpful going forward. I think we have time for maybe one more question and then just some final thoughts. A couple of different questions that have come in have all had to do with this idea of efficiency. And so I'll throw that to the group to kind of combine some of these questions. And I apologize, we won't be able to get to everybody's question tonight, but a number of people have said, we need efficiency. The system can't operate without it being efficient. But at the same time, what happens when efficiency leads to a loss of accuracy and eventually of justice itself, right? The pursuit of a just result in these cases, just because we're trying to move them through the system more quickly. Does that mean that we should limit where plea bargains can be used? Felonies, misdemeanors, we've talked about mandatory minimums already. How are we going to weigh that issue of keeping the system moving forward, but potentially doing some radical things and really changing up the way the system operates in a way that might mean it's going to take longer to get our cases through the system? Jonathan, you want to start us off this time?
Yeah, so I have a lot of mixed feelings about that, because I don't think efficiency should drive the system. On the other hand, in the world that I live in, where everybody is carrying one of these and lots of people are carrying lots of these other machines, and there's endless amounts of evidence. In virtually every case now, there's endless amounts of evidence. We can't go through all of that evidence, and we're not going to go through all that evidence. And so there ultimately has to be some discussion of what process is due and what process, even though it's possible to happen, is not really due. And how are we going to allow a system to operate in a way that's not going to bankrupt everybody in the system and try to get to justice and truth? That's a tough question, I think, these days. Back when I was prosecuting cases, I could carry everything associated with the case in my hands in a single box, what's now called a banker's box. Now that's impossible in almost any case, and certainly in any kind of complex case. So I think, unfortunately, we're going to have to talk a little bit about efficiency. Ultimately, it's going to be about whether the defendant wants a trial. And if the defendant wants a trial, that should be protected and the defendant should be allowed a trial. That doesn't mean an endless amount of process and an endless amount of litigation. So I think there has to be some discussion of efficiency. I wish there didn't. I wish there could be a single process that everybody would say is looking at every single piece of paper, as you could when it was all in a box. I could personally put my eyes on every single piece of paper and every single witness in a case. And that's largely not true anymore. And so I think it's much more difficult. But I think you can have a system that's efficient enough and that is fair to the defendant and allows for a fair trial and one that will get at the truth and at justice. But it's not quite as simple as one thing or the other. And I think you're ultimately going to continue to have to push cases along to some extent. But I think all of this is I think it's possible to get to such a system.
I'll jump in and I'll say that what Jonathan said before is true. He's much more optimistic than I am, but it's inspiring. His optimism is inspiring. But so I would say I want to, and if Jonathan disagrees with me, certainly he can let me know. I do think in the federal system, there's often mounds of evidence. I've worked in both the state and federal system, and what's the difference? In this federal system, the judges actually read your motions and your client is in a lot of trouble. It's, it's all over basically. The state system, I think, is different. And I just want to say about efficiency, this is getting us a little bit away from the trial penalty because we see the trial penalty less in misdemeanors, but we see efficiency concerns a lot with misdemeanor caseloads. And when I was a state public defender in New York, there would be some nights I'd work night court and I would just represent 10 people who had been caught with crack residue in a crack pipe and 10 people who had jumped a turnstile. And that would be, my evening is processing them through the system. And all of them would take pleas because that's efficient. It would be crazy if they all went to trial. And it would crash the system, as Michelle Alexander one time said in an op-ed. I think the question is why are these people being arrested for these crimes? One answer is, well, you can't just let people jump turnstiles. You can't just let people smoke crack on the streets. And, there's a part of that answer that I hear. But I also think this is where, the abolition movement is really trying to change people's minds and change people's thinking. The conversation about efficiency makes it sound like this is the way we should be dealing with societal problems, right? This is the criminal system makes sense as the location of this debate. And maybe the criminal system doesn't make sense as the location of this debate. Maybe we should be thinking about something different. So, efficiency, if you're on the ground, you have to be thinking about it in order to even maintain sanity in order for, and also, by the way, because people would spend very long periods of time in jail. Khalif Browder, for instance, if they didn't plead guilty. But I also think that the efficiency question is based in this idea that we need the system to keep running the way it is. And I would say I push back against that, right? We need to think about why are we processing all these people for possession of crack cocaine, and in this forum, and not trying as a society to think of something else to deal with this issue.
Can I jump in on that, Lucian? So I completely agree with Thea on this. I think that we can try new things. And the amazing thing about living at this particular time in history is that there are prosecutors who are trying different things. So for example, where I teach in law school, there's a prosecutor named Rachel Rollins, who is now, who's one of the people who are just, they're called progressive prosecutors. I don't know if that's the right thing, but she's issued a policy memo that says, I'm not going to prosecute these 11 cases, these 11 kinds of crimes, or 15 kinds of crimes. And we're going to see if that kind of approach works. We're going to see different experiments done where it's not the person is not arrested and brought to court, but they're given a summons. And then if they don't show up, there'll be maybe a warrant out and they'll be asked again to come to court. So I think there's going to be a lot of experimentation over the next 10 or 15 years about how to deal with these very low-level crimes or low-level wrongs. I don't know, we're going to call them something else. And we're going to see how that all plays out. But it's not quite as simple as just, okay, we're going to turn the other way. And Rachel Rollins once in a conversation with me told me that, because when she first said, I'm not going to prosecute petty theft. Well, that sounds great until you get somebody who runs a convenience store and people are walking in and taking things and walking out and not paying, and they know they're not going to get arrested, they're not going to be brought to court, and nothing's going to happen. And so we've got to figure this out, and there is experimentation being done, and I think we have a chance to find a very different system than we've put in place in the 70s and 80s, where it was processing something through a criminal system where the only punishment was jail and the only mechanism was arrest and prosecution. And I think we're going to see through both diversion programs, alternatives to the criminal process for some of these misdemeanor crimes, and even some very serious crimes where there are restorative justice alternatives, whether those can work and be brought to scale. I'm not sure. I'm hopeful, but I'm not sure.
Yeah, I think for too long we've overvalued efficiency. I think that's what I'll say to this question. And it's time for a reset. And I think you've heard some of the ways that that's happening now. And I think there'll need to be more. We've got just a couple of minutes left. So Russ, I'll ask you first, just closing thoughts. We'll go around the room.
Yeah, and my closing thought begins with this efficiency idea, and I think it's time for a societal reset when we think about what efficiency should really mean. I mean, because we've been in, I think, in a period in which the idea of efficiency was captured in the notion of increasing productivity, right? And so if a prosecutor could process 1,000 cases rather than 500, that prosecutor is twice as good, right? And if a public defender can handle 800 felonies, as opposed to sort of their competitor who might be bidding for the same public defense contract in that county that only offers, to handle 500, then the first bid is, the low bidder is going to get the job. We need to start thinking about justice as a scarce resource, and one that if we want it, and both if we want to prosecute people because they are engaged in conduct that's not acceptable or tolerable, and the defense of people who have been accused of committing crimes, we need to invest the resources that make it possible for their cases to be handled with reasonable individual attention paid to those cases. And if we're not willing to expend the resources, then we can expect that we're going to get the justice or the results. So if we think about efficiency as just sort of being, allocating resources effectively, then great. But if we think about it as sort of trying to run the criminal justice system on the cheap, then I'm not at all for that kind of efficiency.
Thank you, Russ. Thea?
So, yeah, I mean, I think my final comments are ones I often make to students, trying to encourage students, even those who are not interested in criminal law, to become interested in their role in the criminal system. When a prosecutor prosecutes a defendant and it says, the people of the state of New Jersey or the United States versus Jones or whatever it is, you're the people of the state of New Jersey, right? Or whatever state you're sitting in, you're the people of the United States. And so this is your justice system. And if you don't like something that you see in it, you can take responsibility for that. You can take ownership of that. You can elect progressive prosecutors. You can lobby to get rid of mandatory minimums. You can court watch. You can sit and watch. I mean, now it's harder because it's the pandemic, but knock on wood, we'll be back live together someday soon. Sit in court and watch what prosecutors are doing. So, I really encourage you, if things you heard today upset you or, make you worry about the future of the system, it's your system. And so, really recognize that and think about the ways that you can contribute to making change, be the change you want to see. So thanks very much.
Thank you. Jonathan?
So thanks everybody for having me. I want to say one thing to the students from Belmont. I'm really sorry that you're not going to the NCAA tournament. I watched the end of that game. It was really sad. But just so you know, I went to Duke as an undergraduate, and we're going to be in the NIT with you. So it's all great this year. Okay, second thing, I have millennial children. So I know the tendency to think that we can't make change, but Thea is right. Change is possible. And let me tell you why I know change is possible, because I've seen it with my own very eyes. Okay, I've seen it. And let me just mention 2 ways that I've seen it. In 2011, the federal prison population was approaching 220,000. And the projections was it was going to grow 7,500 prisoners a year for as far as the eye could see. And Attorney General Holder issued something called the Smart on Crime Initiative. The Sentencing Commission decided to change sentences for drug penalties. The Fair Sentencing Act was enacted. There were budget problems, which reduced the amount of prosecution. Put it all together, from 220,000, today we have 150,000 people in the federal prison system. Change is possible. And on prosecution, I am on a call every single Friday with a whole group of prosecutors from across the country. And I am watching week by week the views of prosecutors changing before my very eyes. The culture that I talked about, which was a culture, and many places still is a culture of efficiency and processing and moving the cogs through the system, it is changing. And diversion, different alternatives to incarceration and prosecution, alternatives to prison. There are new things happening. They're happening all over the country. Change is possible. So I'm with Professor Johnson. Go out and make it. And by the way, I'll be with you arm in arm.
It's a very positive way to end our discussion. We've talked about some very difficult issues, but there's a lot of work being done to correct it. And as Jonathan said, I think change is coming and the system is getting better. I hope that you'll take a look at the FAMM website to find out ways that you can participate and help if those are issues that you're interested in. Also to look at the American Bar Association Criminal Justice Section website. One of the really unique things about the ABA Criminal Justice Section is that we're made up of prosecutors, defenders, judges, academics, people from all corners of the criminal justice system who come together to collaborate on what the future of criminal justice should be and how the system should operate. So I hope you'll think about taking a look at that as well and becoming actively involved in that work. Thank you again to all of our panelists. I really enjoyed the chance to talk about these issues with you tonight. Thank you to all of our sponsors and to our hosts, and have a good evening. Thank you. Bye.